Okay, let's get started. Hi, everyone. My name is Julian Nava. I'm a staff attorney with NCAI, and I work with John Dawson and our legal team on taxation issues. I wanted to thank everyone for joining today's call. I know that we gave a late notice, but thank you so much for jumping on the call today in regard to the Indian Trader consultations that are coming up, as well as issues of dual taxation. So today I'm going to be controlling the webinar, and I wanted to walk you through just briefly our control panel so that if it's your first time attending, you'll know what to do. So I'm going to click to the next slide. So there's a control panel that you should see on your right side of your screen. And I'm going to walk you through a little bit of what this entails. So if you can see the highlighted portion in red, this is to open and close your panel. I'm going to close it. That's what it would look like. And this is the view, select, and test your audio. And it's important that if you plan to ask questions that you enter your audio PIN, which is specific to you and to your registration. So you should have that. If you do have any problems with your audio PIN, just make sure to either queue up a question or raise your hand on the icon provided on this control panel. And this was your audio PIN should be provided something like this with your registration. This is the raise your hand icon, so you can press that, and I'll see it on my side. And I'll know that there's a question that's in the queue, and then you can type your questions here, and I can see that as well. And during the presentation, we can provide your questions to everyone that's online. In addition, this webinar is recorded, so if you miss anything during the presentation, you'll be able to view it via our YouTube page. In addition, as part of this webinar, we've provided 3 handouts for your review. One of them is a one-pager for general taxation issues in our Indian Trader regulations. Another one is a 24-pager, which gives you an outline of those issues and just expands on what we've been working on. And the third attachment is an economic analysis from Jonathan Taylor, so that you can review and understand the economic, implications. And those are your handouts that are provided in the control panel. So I think I've covered everything. John, I'll hand it over to you.
Thanks so much, Julian. If you go over to the next slide, and I think Colby Duran is on the line with us today. Maybe one last time, Colby Duran is a staff attorney. He's moving on to the University of Arkansas Agriculture program. So thanks for being with us today, Colby.
Thank you, John.
As background on this, the Department of Interior has been amending its regulations in a number of areas recently. I think many people may remember that the leasing regulations were amended, attempting to streamline the leasing process for tribes, make it clearer. That was a big project in 2012 and then the year before. And one of the great things about these leasing regulations is they clarified the issue of permanent improvements on Indian land and made it clear that they are not subject to taxation. Tribes worked a lot on this. It's had really good results. In the 11th Circuit and the 9th Circuit, they've upheld these decisions that states and county governments don't have the authority to tax permanent improvements. If you go to the next slide, the Department of Interior has also amended the right-of-way regulations. And here they did these are more recent, and they made a similar change to make it clear that states and counties cannot tax rights-of-way on tribal lands. Also a good development. We have yet to see any litigation out of this, at least not that I've seen. But this is improving the regulatory processes at the Department of Interior. So if you go to the next slide, there is some litigation that's ongoing right now as well. State of Washington versus the Tulalip tribes. This was a very innovative lawsuit brought by the Tulalip tribes against Washington State, seeking relief from state taxes at the Calceta village. And one of the arguments the tribe has brought, in addition to tribal sovereignty and the Indian Commerce Clause, is that federal taxes are preempted under the Indian trader laws. The Department of Interior and the Department of Justice intervened in that litigation and said, yes, that's right. They've asserted a federal interest as a trustee and cited the Indian trader statutes. I think that caught our attention as far as the importance of the Indian trader statutes. And then we started reading the Indian trader regulations. So if you go to the next slide. This is 25 U.S.C. 262. This is what I think of as the action part of the Indian trader laws. It gives the Secretary of Interior, and it says the Commissioner of Indian Affairs, which doesn't really exist anymore. That's all been reorganized. It's now basically the Assistant Secretary for Interior. Any person desiring to trade with Indians on any Indian reservation shall, upon establishing that fact, be permitted to do so under such rules and regulations as the Commissioner of Indian Affairs may prescribe. So it's extremely broad discretionary authority for the Department of Interior to write regulations about not just business licensing on reservations, but basically anything having to do with trade or business on reservation. It probably does not apply to transactions between non-Indians on non-Indian fee land, but on tribal land, it looks to us like this could definitely apply to even lease transactions, about retail sales out of leased buildings, energy, all types of economic development transactions. Some people have raised a concern that that these are paternalistic old laws. If you go to the next slide, and I've heard this out of we spent a lot of time trying to convince the Department of Interior that they should consider doing this, and a lot of the feedback we got was these are paternalistic old laws. Why would we even look at those? And I guess I wanted to make the point that there was a period of time before paternalism, basically when the tribes were at war with the United States, and it was much more of a sovereign-to-sovereign battle in the early days of the United States. And that's when the Indian trader laws came into place. They weren't intended to be paternalistic. They were basically intended to stop Indian tribes and the non-Indian settlers from killing each other. This is a letter from Henry Knox, who was the Secretary of War, to George Washington in 1790, right as they were ratifying the Constitution. Indian wars almost invariably arise in consequence of disputes related to boundaries or trade. So right at the beginning of the Republic, they were trying to regulate trade on Indian reservations. If you go to the next slide, this is George Washington getting back to Henry Knox. I really want you to produce some regulations for trade in with the Indian tribes, and making it very clear that what steps can be taken with them to restrain hostilities. At least I'd like to think that there was a period of time in American history before paternalism towards Indian tribes when it was really much more about military issues, and trade was a part of that. Regulating trade was important economically, and it was important militarily to the United States, and that's the origin of the Indian trader statutes. If you go to the next slide, you can see it in the first trade regulations from 1790. The superintendents license trader in their respective districts. They get to assign the limits, and the military aspect of this, the traders were supposed to give intelligence to the United States. So these are since 1790, this licensing of Indian traders has been the system. Now, if you go to the next slide, these are the current regulations, 25 C.F.R. Part 140, and they're still really kind of the same thing as they were in 1790. Any person other than an Indian of the full blood who attempts to reside on an Indian reservation as a trader or to introduce goods or to trade therein without a license shall forfeit all merchandise. This same structure of federal licensing of Indian traders has been in place for the entire history of the United States. The current regulations date to 1957. They're unbelievably outdated. For example, they prohibit gambling on Indian reservations. Obviously, that's been replaced by the Indian Gaming Regulatory Act. They implement a statute that was repealed in 1996. There may be, at least in my mind, no better example of the federal neglect of economic development in Indian country than the Indian Trader Regulations. These are the regulations where the federal government has all the authority to regulate and help economic development, but they basically haven't done anything in hundreds of years. If you go to the next slide. So that's just a little bit of background on this stuff. We've been, tribes and NCAI, and there's been an NCAI resolution, and many tribes have been promoting the Department of Interior consider taking a fresh look at the Indian Trader Regulations. And they've agreed to do so. There's a series of consultations that are being scheduled across the country. The first one is tomorrow at the Swinomish Reservation. The purpose of this webinar is to provide some background, help people get prepared for these consultation sessions. And the proposal that we've put forward to the Department of Interior is that they would basically bring the Indian Trader Regulations into the era of tribal self-determination. And the first step of that is that the licensing of businesses on reservations should be done by the tribes themselves. That the statute says all that needs to happen is the secretary has to be satisfied that this is a proper person to engage in such trade. It seems to us that it's easily within the scope of the secretary's authority to delegate the licensing function to tribes, as long as the tribes have some sort of licensing system in place, probably some minimum standards where the tribes would, they would be licensing businesses on the reservation. Many tribes already have business licensing in place. It's a fairly simple system. It's as easy as keeping a list of, and then if there are bad actions or an unscrupulous business or a fraudulent business, the tribe can take away their license and then forbid that person to engage in business on the reservation. The system could be as simple as that. Of course, it can be more complex. Some tribes, compatible uses. You don't necessarily want a lead smelter next to a school, but those are the types of things that tribes and cities and towns regulate with business licensing. So this is probably the main part of the proposal, is to get away from the old federal licensing system and allow tribes to do their own business licensing. There are a few reservations left in the country that use the licensing system. Tulalip is one place. I think Navajo and Hopi, there are still some federal trading licenses going on. But at most places around the country, if you ask the superintendent's office, they wouldn't even know how to find the process for doing an Indian trader's license. So these regulations are observed much more in the breach than they are in actual practice. So we would propose that those systems that remain in place would stay grandfathered in for as long as they were needed. If you go to the next slide. The other part that I think many people were familiar with the litigation last year in Dollar General versus Mississippi Choctaw, where there was a business located on the reservation, and the question was whether the tribal court could have jurisdiction over the action of one of the employees, in that case an assault on a minor within the store. And ultimately the Supreme Court of the United States couldn't decide. They split 4-4 after the death of Justice Scalia back in January. And this is an open question right now for federal Indian law. It's interesting that if you go down to the next slide, there's another set of regulations, that Indian Trader Regulations, that are specific to Navajo, Hopi, and Zuni. And they have in their regulations, and these are current law right now, that anyone doing business on the reservation consents to tribal jurisdiction. These were put in place in the early 1980s under the Reagan administration. I don't think they're that controversial. If you go back up to the previous slide, at least our proposal would be that there would be a basic presumption of tribal jurisdiction, that it could be modified by contract. Obviously, tribes are doing a lot of businesses with banks and other people who may, the choice of forum clause is something you could still do in your contracts. The way we thought of it was that incidental transactions, there would be a general license, or it would probably not trigger federal court jurisdiction if you were just or tribal court jurisdiction if you were just buying gas on an Indian reservation. But it would take deliberate and knowing engagement by a business that would trigger tribal court jurisdiction, and it would answer a lot of the problems that were raised during the Dollar General litigation. So if you go down 2 more slides, I'll get to the third part of our proposal. The third part, and this part gets a lot of attention, but the other 2 parts are important too. The third part would be to make clear rules that preempt state taxation on Indian reservations. The law provides the Secretary of Interior with really broad authority under such rules and regulations as the Secretary of Interior may provide. So our thought was that the Secretary should follow through on what tribes have been asking for decades, basically ever since the Cotton Petroleum decision: reaffirm tribal tax authority, preempt all state taxes on tribal lands, and specifically to preempt mineral and energy taxes. Clarify the rules about the tax sourcing for retail, delivery sales, internet sales, long distance sales. Make it clear that tribes will have the authority to collect taxes on those transactions if they want to. Excise taxes like motor fuel and tobacco, personal property taxes. I mentioned earlier the issues with wind generation and solar generation and the problem with personal property taxes. And then finally, it would acknowledge the ability of tribes and states to reach tribal states agreements on tax issues. There are often services that both the tribal community and the surrounding community rely on, like a fire department. So you could reach agreements about those, but those would be optional to the parties and not required. And then if you go down to the last slide, the Department of Interior, well, maybe it's a little bit small, but you can sort of see it here. The Department of Interior has decided to move forward with these proposals, at least in a preliminary way. They've done what's called an advance notice of proposed rulemaking. They haven't proposed a new rule. What they've said is, we'd like to talk to you about it, and let's get comments and start a process. So that's what an ANPRM, or an advance notice proposed rulemaking, is really the very beginning of the process, and that's where we are right now. The first meeting is tomorrow. I wanted to, these meetings are going to take place around the country. On March 2nd, they're going to be at Rincon. On March 7th, they're going to be in Billings, Montana. March 9th in Rapid City. March 13th, they're going to be at the RES conference in Las Vegas. I think many people will be there. March 14th at Shakopee, and March 16th up at Seneca. So there's a series of consultation meetings upcoming, and we mostly wanted to give this background as a way of people getting prepared to give comments. As far as the comments, that we've attached a 1-pager of talking points, some more detailed background, and then that economic analysis that Jonathan Taylor and Kelly Croman did about the problem of dual taxation, to provide some background information for you to get ready for these consultation sessions. We think it's important to make all 3 points, about empowering tribes to do their own business licensing, about tribal court jurisdiction, and then thirdly, about taxes. It's easy to focus on the tax issue, but the focal point of the Indian Trader Regulations is really about business licensing, and that's also a very important process. So the comments should hit all 3 of those points. And I guess that's my overall summary. I'll leave it at there, and I wonder if there's any questions or discussion.
If you have any questions, you can either write them in the box on your panel, or you can raise your hand.
So no questions at all. It's pretty straightforward, and we're very early in the process. But these are fairly new concepts, the idea that the Department of Interior could do this by regulation. So that's why we wanted to talk to folks about this in advance. I'm sure many tribes have stories about the problems of dual taxation, about problems with jurisdiction over businesses on reservation. So those kinds of issues and background will be really important to provide at the consultation sessions.
No questions at the moment.
All right. Well, maybe how about opening up all the lines? Is that a possibility? And seeing if anybody wants to discuss.
Okay. Yeah. Or NCAI. Okay, I'm unmuting everyone's line, so if you have a question, please feel free. They haven't dialed in, so okay. Yeah. Yeah. They're self-muted. Okay. Hey, John, can you talk about whether or not this is our only webinar, or whether we're going to do another one of these? Hey, John, you there?
Actually, can you hear me, John?
Go ahead. We can hear you.
Oh, okay. I just want to say I thought that was a terrific summary that you made. The one comment I've got is that on the tax issues, particularly oil and gas and other, well, let's just talk about oil and gas right now. It seems to me it's going to take an act of Congress to change the law on that. The Interior can't just make a regulation that would change it when the Supreme Court's already ruled on it. But it was a terrible ruling by the Supreme Court.
Like what, 1994 or something like that? And that's just not happening. So we're looking at this regulation as an alternative route. I think it, at least one view of this, and there are, Supreme Court, that the Supreme Court decision in Cotton Petroleum is a common law decision, and it could be displaced by positive law, even a regulatory action, as long as it's based on, clear authority from Congress. And the authority under that 262 section is really broad. So, I am not going to argue with Henry Saxe about legal issues, but at least what we're trying to put forward for consideration is that the agency does have very broad statutory authority to write regulations that would preempt state taxes in Indian country.
Oh, it's Harry again, and I think it's worth a try. It's nothing to lose in that. It'd be terrific to get a regulation that said that. Then we could.
There would be nothing to lose, right?
I really do like the rundown of this that you've given. We sent a memorandum to our clients, so I've looked into it too, and I think what you're saying is just exactly right.
Well, thank you. Yeah, I think once you get into it, there's a lot of little issues that come up. The status of different types of land, and I think those will have to be worked out as we, if we ever get a proposed rule to work on. But right now we're in, I think, the big picture principles stage of the discussion. Any other comments?
Yes, there's a question that's in the queue. It's what is the relationship of the proposed rulemaking with the Montana line of cases?
I guess I think of it as the, there's not so much the Montana line of cases, which were about, tribal jurisdiction over non-Indians, a civil jurisdiction. This is, the line of cases that's more about tribal taxing authority. And it seems like all those cases seem to come off the Jicarilla Reservation. There's the forestry case off of Jicarilla, and then there was Cotton Petroleum, and a series of Warren Trading Post. And to some degree, it's an answer to that line of cases for the Department of Interior to make positive law about the tax rules on Indian reservations. And that's what we're hoping they'll consider.
John?
Yes.
John, this is Diane Gange of the Jamestown Tribe. And
hello.
My question is, we've worked with the state of Washington quite a bit on the BIA leasing regulations issues, and that we thought were pretty clear as it related to exercising taxing authority, et cetera, at least on the lease land piece of it. And we're just still, the state does not, they keep questioning, they actually even questioned the authority that the BIA had, as far as was that enough authority when they released the leasing regulations to allow the state to take that into consideration when they determine taxing issues. So is the language in the regulations that we're going to try to get on the new regulations on the trader going to address that? I mean, is it going to be so clear cut that they can't come back and say this really doesn't apply? Are there ways that we can do something very strong? Or is that too specific for right now's discussion?
No, I think it's a good question. And maybe, Julian, if you go back up to like the first substantive slide, we can look at the leasing, the language in the leasing regulation on taxes. And I'll show you the part that I think is causing at least some of the trouble. Can we flip back up to that leasing reg? It's like the second slide in the stack.
Okay.
Oh, there you go. Great. And you see how the leasing regulations are written subject only to applicable federal law, which I'm not really sure what that means. I think that was, the department trying to hedge a little bit because they were trying to figure out what all of this meant. To some degree, I think that phrase complicates the analysis because it starts to bring in like, oh, well, maybe we got to go take a look at all these Supreme Court cases and do the balancing test.
And that's exactly where the state of Washington is, John. That phrase right there is exactly what has caused them a lot of grief. I
think we got to get away from that and get away from the balancing test. The balancing test, it is a common law answer to the problem of, state taxes on Indian reservations. And it's not a very good one. It doesn't work. It's really fact intensive. It gets litigated in every situation. Nobody can figure out what it means. And when it does get applied, usually they find a way to rule for the state rather than for the tribe. So at least our goal would be to get away from the balancing test entirely and just make it clear that on tribal lands, and at least our thought was not to try to apply this to fee lands within a reservation boundary because it doesn't fit within the frame of the statute. But for for tribally owned lands, for trust lands, or restricted fee lands. All of those lands would have a very clear set of rules that no state tax authority, the tribe has the tax authority.
Perfect, thank you.
Any other discussion is great. We talked to tribes, a lot about this issue over the last year, and I've just learned a ton from you guys. Anyway, maybe flip back down to the schedule of upcoming consultations. I think that this first one at Swinomish hopefully will be fairly well attended. There's a lot of tribes in that part of the country. I certainly encourage everyone to come out. Then the next one is going to be at Miccosukee coming up next week. There's 2 federally recognized tribes in Florida, not as many tribes down in that area. I certainly hope people will show up there. And then we'll go through the series of consultations. NCAI, we're planning to attend probably most of them, if not all. And, we'll try to hand out talking points and keep the discussion going. But obviously, at these consultation sessions, the tribal leaders carry the load. So getting tribal leaders, prepped up and ready to talk about these issues is going to be important. All right. Well, if there's, Julian and I are going to be working on this for the foreseeable future. If there are any questions or you'd like any further information, please contact either one of us. And if there's no further questions or just, oh yeah, go ahead.
There's a question. Let me try to get to it. Okay, so we have 2 more questions. So the first question is, what are your thoughts in regards to tobacco, alcohol, and fuel taxes?
Our thought was to make it, generally with these regulations, you want to be, if you just make a general rule, everybody tries to find exceptions to it. So our thought was to make it specific, that tobacco, alcohol, and fuel taxes on Indian lands, the state taxes would be preempted and tribes would have the sole authority to tax. That would run into, there's a lot of agreements around the country where either through state laws or through compacts or some combination, states and tribes have come to agreements about the sales of alcohol and tobacco, and those vary quite a bit. They vary from, in some places it's a revenue sharing agreement. In some places the tribe gets 100% of the tax. In some places it's a volume or quantity of untaxed tobacco. So those agreements vary a lot. We wanted to make clear that if tribes and states want to keep their agreements or if they want to strike new agreements about taxes, that's perfectly acceptable. But that there would be a set of clear ground rules that no state tax, the tribe has authority to tax. One story from Swinomish, and I bet this will come up tomorrow, is when the leasing regulations went into place, the county up there, they realized that they were going to lose $6 million in tax revenue to the tribe, and that revenue helped to fund the fire station that both the tribe and the county relied on. So they worked out an agreement where the tribe gets the revenue and the tribe helps to fund the fire department. So it seems likely that agreements like that are going to be needed, particularly where there's services that are used by both the tribe and the surrounding area.
I think you just answered the next question, and that's what do you do with existing tax agreements between states and tribes and the shared taxes?
Keep them, change them. It's up to you. it may be that there's, I mean, it's my hope that the work that we're doing here, and then if you saw Jonathan Taylor and Kelly Croman's paper, is really great. That this will cause a new look at the problem of dual taxation, and that states and tribes and local governments will be looking at their tax agreements and looking for ways to empower tribal governments to collect taxes and raise the revenue they need and provide the services they need to provide.
Okay, we have another question, and I think we talked about this earlier, John, but are we going to draft a sample comment letter so that tribes can use it if they're not able to attend any of these consultation sessions?
Yes, we're working on that. I've got a draft that I need to review, but yeah, we'll have sample comments, and NCAI is planning to submit comments. I know there's a number of tribes who are also following this issue fairly closely and will likely be submitting comments. At this stage, I think it's important to read the Federal Register notice for the advance notice of proposed rulemaking. It lays out a series of questions and I think our comments are likely to follow. I think there's 7 questions, so our comments are likely to answer those 7 questions. And then, if there's other points, we'll raise those as well. I think the 7 questions are really helpful because they address not only the tax questions, but also business licensing and jurisdiction over, tribal court jurisdiction over businesses on reservation.
Okay, next question. Should we be concerned with state opposition to updating these regulations? And if so, how do we address that?
I think there's definitely going to be state opposition. I mean, we're talking about taking tax revenue away from states. The states aren't going to like that. They resist that almost everywhere in the country. There's a long history of litigation about this, and it's basically, states versus Indian tribes on a whole string of Supreme Court cases. So we are going to see resistance. I think the answer is the problem of dual taxation is that the states are collecting all the revenue, but they aren't providing services or very little services on the reservation. There's that economic analysis that's on their webinar that's pointed out there. I think that's the answer, is to just focus on the economic analysis, the problems that it creates for tribal governments, and just keep pushing that message forward. This administration is really supportive of economic development and building infrastructure and rural development. And I think we've got a fairly good argument that dual taxation is one of the major barriers that prevents tribes from moving forward. So we've got strong arguments, and I'm sure there'll be opposition. We just need to keep making our arguments.
Okay, it looks like that's it.
All right. Well, thanks very much, everyone. I hope I see all of you at Swinomish tomorrow. And if not, I'll hopefully at one of these consultation meetings down the road. Looking forward to it. And if you have any questions or comments, please let Julian and I know. Thanks very much.